Hi guys, very good morning. How are you doing? Hope you're all fine guys. Hope you slept well. So let's begin today, day number 2. Good morning all of you. Those of you who wished me, thank you so much. Let us begin buddies. So yesterday we finished 17 pages. So today also we need to finish around 17 pages. That's the target, 16, 17. Because we have around 71 pages to go. And let us begin. Alright. So coming to the variation in the terms of the contract. So yesterday what we were doing guys, we were doing the prospectus, chapter number 3, prospectus and allotment of securities, right? So let us go ahead with the other areas today. As far as the prospectus is concerned, what do you mean by a prospectus? Prospectus is something which is an invitation to offer, and there are various types of prospectus that we need to see. But generally prospectus is issued by a public company and not a private company. Private company, they issue shares through private placement or right issue, whereas public company will do through the prospectus method, or of course they also have the private placement or the right issue. Coming to the deemed prospectus, so of course if I give the prospectus to the underwriter, then that will be called as a deemed prospectus. That is one part of it. On the other hand, we have couple of other types of prospectus that we need to study today, and that is called as the shelf prospectus and the red herring prospectus. So what is red herring prospectus? Very simple guys. If I take like a normal scenario, if there is a initial public offer as such, the initial public offer, the company will appoint certain people, and those certain people are called as merchant bankers or underwriters. So merchant bankers or underwriters are appointed by whom? The company. And the underwriters or merchant bankers will appoint further people known as the lead book running managers. Lead book running managers. And under them, they have sub underwriters or sub lead book running managers. Very simple guys. Rather than fixing the price on my own, it is always better, mind you, rather than fixing the price on my own, it is always better if I launch the company for a price which the people are ready to pay. So without fixing the price, can I launch my company in an initial public offer? Answer is yes. That concept of without being fixing the price but ascertaining the price through the mechanism of asking the shareholders, prospective shareholders, is called as a book building offer. Book building offer. In book building, what do? Is I don't fix the price, but I will give a price band. I will give a price band. There will be a base price called as the floor price. Let us take for example 100 rupees, and there will be a cap, the final price. The cap will be 20% maximum variation. So it will be 120 rupees. Let's take an example. So between 100 to 120, there will be a cap. So this price band will be given to people, and the people will ascertain the share prices. Who are the people who ascertain the share prices? They are called the QIB, qualified institutional buyers. So obviously when I am giving it to them, I have to give a prospectus. The prospectus which does not contain the price of the securities, but which contains the price band, which can be where through this entire mechanism of the book building offer, the price of the securities is ascertained through these big shots called QIB, qualified institutional buyers. So that concept, that prospectus is called as RHP, red herring prospectus. So you would have seen that most of the companies go for red herring prospectus through a book building offer, because it's better if the price is fixed by others, by this big shot investors, rather than the company, because company may not know its worth. So they will rather ask the others to do so. That is called as RHP, red herring prospectus. Got it? So that if you see now, red herring prospectus, let us see, check it out. So in the red herring prospectus, price of the securities will not be there, but the quantum of securities will be there. Where the price of the securities is not there, but quantum of securities is there, that's called RHP. A company proposing to make an offer of securities may issue a red herring prospectus prior to the issue of a prospectus. So once the main prospectus, once the price is ascertained, RHP will be replaced by a normal prospectus. Red herring prospectus is filed with the ROC 3 days before the opening of the subscription list and offer. When red herring prospectus is filed, when is it filed as a prospectus? Very simple. When the total capital raised is there and the closing price. The QIB will decide the closing price and the company will fix the closing price. So in that price band of 100 to 120 that I explained, if they fix it at let's say 118, then the red herring prospectus will be converted to a normal prospectus. That's the difference between RHP and normal prospectus. Red herring prospectus is different from normal prospectus. That is what they say. Very, very simple. So price of the securities and quantum of securities are the two things that we need to keep in mind. On the other hand, what do you mean by shelf prospectus? There are many, for example, financial institutions which issue debentures, bonds, etc. Now during the year they would have planned many things, guys. Like they would want to issue one in April with a 7% interest. Then they would want to issue one sometime in August with a 8% interest. So and then they also would have planned to issue sometime in December 7.5% interest, whatever the case may be. Now every time I am issuing during the year, should I give a prospectus? Technically yes. But for all companies who have a certain plan for the entire year, where they have multiple issues, rather than that, what will they do? They will not give a prospectus, rather they will give something called as a shelf prospectus at the beginning itself. At the beginning of the year, for 1 year, they will give something called as a shelf prospectus. Shelf prospectus, right? So the shelf prospectus is what they keep. At this shelf prospectus, they will say during the entire year, this is my plan, I want to invest in 7%, 8%, 9%, 10%, like that they'll give. That is the shelf prospectus. But on the other hand, they will also tell one thing, in the 7%, 8%, whatever it may be, if there is any variation between this and this and this, whatever it is, before every issue, they will also give a comparative analysis between the previous issue and the current issue. A comparative analysis between the previous issue and the current issue. This is called as IM, Information Memorandum. So shelf prospectus starts off with the prospectus also, and it will also contain the IM, Information Memorandum. So both things put together will be called as shelf prospectus and information memorandum. So let us check out what we are discussing here. Check it out, guys. So you see shelf prospectus. Any company may issue shelf prospectus if they have more than one issue over a certain period of time. That certain period of time will be 1 year. Shelf prospectus may be filed at the ROC at the stage of the first issue itself. 1 year validity is given, no further prospectus is required for further issue. One time shelf prospectus. But between the two offers, I need to give a comparative statement that is called as an information memorandum. So going ahead here, every subsequent issue, company needs to file information memorandum only containing new charges created, if any, change in the financial position, etc. This will be in PAS 2. So it should be filed before 1 month of the issue. If any advance money is received also, the company shall intimate the changes if required. And if they have, changes are not required or changes are not intimated, then they have to cancel that issue and refund the money within 5 days. So this is with respect to the shelf prospectus. So those are the three types of prospectus, guys. One is deemed prospectus, red herring prospectus, and then we have shelf prospectus. Deemed prospectus, red herring prospectus, and shelf prospectus. Got it? Very simple. That is with respect to dematerialization of securities and all those things. So this completes the with respect to prospectus. Then with respect to the allotment and subscription money, basically how much money will be the application value? The application value shall not be less than 5% of the nominal value of the securities. So basically if the nominal value is, let's say, 10 rupees, or let's say 100 rupees is the nominal value I have fixed at, it shall not be less than 5%, means I can collect 5 rupees as the application money. Whatever the case may be, should the minimum subscription be taken? Yes. If the minimum subscription amount, that is when you issue shares, if the minimum subscription amount is not received within 30 days from the date of issue of the prospectus, then you must return the money within 15 days of the closure of issue. Very simple. So first 30 days time is given, then 15 days extra time is given. You need to return the money. If you do not return the money, then it will be considered as a default and you will have to pay an interest of 15% per annum. 15% per annum interest has to be taken, has to be considered, is what they are trying to tell. Got it, buddies? That is section, after between 30, 31, 32, where the rules, we will take that. Coming to section 33, issue of application form of securities. So every application issued, when I am issuing shares, there are two types of application that I give it to shareholders, guys. One, the shareholders can go through the normal route, that is the stockbroker route, right? Shareholder can go, let me just change this. Shareholder can go through the normal route, that is the stockbroker route. They can apply for shares with the stockbroker route. The SEBI has identified top stockbrokers who will look into the initial public offer. All the bidding etc. can be done through stockbrokers, or you can go to the group of banks, because if the brokers are not available, then you can go to these villages etc. may not have access to broking facilities. So they can go to the group of banks selected by SEBI, approved by SEBI. They are called as syndicate bank. Syndicate bank is not that Alsatian dog, not that bank. Syndicate bank just generally means a group of banks. They can authorize. So you can deposit some money in this syndicate bank, that is called ASBA, application supported by a blocked amount. Application supported by a blocked amount. They can block it and then they can purchase the shares here also. So one is with respect to the stockbroker, one more is with respect to the syndicate bank, that is the ASBA investors. Group of banks, syndicate bank, talking about the ASBA investors. So that is the thing. Every application issued of what? How will I apply? Either to the broking route or the syndicate bank route. When the company issues the application, they should ensure that they will give me the salient features of the prospectus. Generally prospectus will be 400, 500, 600 pages, but they need to give me the salient features, important features. That is called as abridged prospectus. Abridged prospectus. Abridged means concise. So they will give an abridged prospectus. So if the abridged prospectus is not provided, then there will be a penalty of around 50,000 rupees. And it is not required. When will the prospectus not be required? Whenever the securities are obviously not issued to public. I am doing a private placement. I don't need any prospectus. And also there is a proper bona fide underwriting agreement between me and the underwriter. That's why prospectus is not required. That is only called as the deemed prospectus. Normal prospectus is not required. That concept only is called as deemed prospectus because it is not needed anyway. Now, the important area that we have to consider is section 34, criminal liability for misstatement in prospectus. Generally, they have asked this for around 4 marks. They keep asking, what is the criminal liability for a person misstating the prospectus? What will happen if you create this misstatement? What would be the criminal liability is what we need to understand. Now, coming to this situation. Prospectus issued, circulated includes only statement which is untrue or misleading. Where any inclusion, so basically any prospectus which is considered to be misleading. There are golden rules of prospectus which says that the prospectus should tell the truth, only the truth and nothing but the truth. Even if you mislead the people by lying or even by suppression of information, that will be dangerous in the larger scheme of things. So where any inclusion or omission of any matter is likely to mislead the public, then what happens? There will be this criminal liability in the prospectus. And what is the liability or punishment? Every person who has authorized the issue of the prospectus will be liable under section 447. Very, very important. You need to remember 447. 447 is punishment for fraud. So in that case, what 447 says? Imprisonment, minimum 6 months, maximum 10 years. Fine is an amount equal to fraud, that also I have to pay, or that is maximum is what? Minimum is amount equal to fraud, maximum is 3 times the amount of fraud. 3 times the amount of fraud. So basically imprisonment is what, guys? Minimum 6 months, maximum 10 years. Mind you, you can never escape imprisonment by paying fine, because the act uses the word and. Not only do you have to pay fine, but also you will be imprisoned. Right? Fine plus imprisonment. If fraud involves public interest, public is involved in the entire thing, minimum imprisonment will be 3 years. So it is 6 months to 10 years, or it will be 3 years to 10 years, depending on whether it's public interest or not. Dangerous liability. Apart from that, protection. Basically, protection is also there, especially for expert or even for directors, etc. If they feel that such statement or omission was immaterial to the entire prospectus, or he had reasonable grounds to believe that that particular thing was true. For example, expert has to give a certification. In the expert certification, he will only certify those things provided to him by the management. What if management only had given him wrong information? In that case, he can escape the punishment if he can prove that the management had given wrong certification, wrong details, all these things, right? Is it important to remember penal provisions, is what one person is asking. Guys, always remember penal provisions. Everything, if you can sit and remember, it will not be possible. So what you can do is you can only choose important areas and then you can remember. For example, 447 you have to remember, no choice and no other option. Section 447 you have to remember. But every penal provision should I remember? Not needed. Only choose those ones which have been amended recently. Second, choose those ones which can come in the exam. In what way? Like important ones, like for example 128, 129, 447, all these are important penal provisions, right? And those things which have been amended recently, that also will become important. Maybe around 10-15 penal provisions you have to remember, other things not possible. It is humanly not possible to remember, guys. So even if they ask in the question, you can say, okay, leave it, that part I'll leave. Because the amount spent on learning the penalty, which will be far more than the marks that comes in the examination. So study some 5 to 10, that is enough, right? Next. Cool. So civil liability is very simple. This is criminal liability, guys. Criminal liability is this. Civil liability is under 35. Where a person has subscribed for securities of a company acting on any statement which is misleading, then who is the person liable? The company also is liable, and every person who is the director of the company, authorized to be a subscriber, promoter of the company, and authorized the issue of prospectus, that is nothing but the expert. Expert also will be liable. Expert also will be liable. Yes, before issue it has to be registered, correct. Next, nature of liability. Liability to pay compensation to every person who has sustained such damage. Personal liability is there. Personal liability, this is the concept of lifting the corporate veil. They lift the corporate veil and make the liability, personal liability. Every person shall be personally responsible for all any losses incurred by any person. So there will be a personal liability on all these things. Will there be protection involved? Yes. Such person shall not be liable. Which person? This is the protection. This is an important thing. They will ask, when can the expert escape punishment? When can the expert escape punishment? 4 marks. Right? When can the expert, escape punishment? If a person withdrew his consent before the issue of the prospectus after giving his consent. First, consent will be given, then after giving the consent, if he withdraws, then it will be done so. Second, if it was issued without his authority or consent. So basically you took an expert opinion without taking his consent, he just put some random figures and that only you took it as the final thing, wrong answer. That cannot be done. Next, prospectus was issued without his knowledge. Prospectus was issued without his knowledge. Then on becoming aware of the same, he has given public notice telling that they have issued without my consent. So the expert will send a draft opinion to the company. Company without taking his consent directly will print it in the prospectus. That is wrong. So if an expert gives any misleading statement or evaluation, director has to prove that it was a fair and correct summary of the same and he had reasonable. This is for the director. When can director escape? He will say, boss, look, I am not the expert in share valuation. He is the expert. Whatever he told me, I followed. Then only it will say. So that is the thing. That is as simple as that. He had reasonable ground to believe that the expert was competent to make the statement, is what they say. Next, section 36 talks about punishment for fraudulently inducing a person. Fraudulently inducing a person to invest money. Can I fraudulently induce somebody to invest money? Yes. So, nature of the act causing any person who knowingly makes any statement which is false. Induce means to fraudulently ask somebody to invest in the company. Though you know company will not do well, you just want the money. So, you induce somebody to invest. That's the thing. To induce one other person to enter into any agreement to acquire securities, any agreement for the purpose to secure profit via fluctuation, whatever the case may be. See the punishment again, what happens? Section 447. The punishment will be under section 447. 447. Next, that is section 36. Next, moving on to 38. Punishment for personation. Personation means impersonation, using somebody's identity. By falsely using the KYC documents of somebody else, forging somebody's signature, whatever it is section 447. If a person who makes an application in a fictitious name is different, makes multiple applications to the company in different names, in different combination. Your name is Sri Harsha. I'll first make an application in the name of Harsha. Next I'll make an application in the name of Sri. Next I'll make an application in the name of Sri Harsha. Then I'll make an application Sri H. Then I'll make an application in S Harsha. Everybody same person. Gone. That is called personation. Then otherwise induces directly or indirectly to allot or transfer shares in a fictitious name. In all these cases it is be a problem. What will you do? Disclosure in the prospectus. Every such act and punishment shall be disclosed in the prospectus, and I will dispose of the securities. If you have obtained something fraudulently, the company can also, company can apply to the court, NCLT. NCLT may order return of any gain and even disposal. They can ask you to sell the shares. And any amount that you have received through disposal of securities, when the company sells the shares, company cannot make money, guys. When the company sells the shares of such people who have cheated, amount should go to whom? Investor Education and Protection Fund. Investor Education Protection Fund. IEPF, Investor Education Protection Fund. That is with respect to section 38. Moving to 39, minimum subscription. What is the minimum subscription amount needed? Minimum subscription is the minimum amount stated in the prospectus for which shares are allotted. The quantum of subscription is very simple. Under Companies Act, it should be amount stated in prospectus. Under SEBI guidelines, it should be minimum 90% of the total issue size. So under Companies Act, it is whatever the amount stated in prospectus, but as per SEBI, minimum 90% of the issue size must be there. So I can take it as 90% or Companies Act, whichever is higher, right? Because Companies Act can, prospectus can say 95% should be the minimum subscription amount. If the subscription amount 90% is not met, the subscription amount 90% is not met, then what will happen? It will go on to the, if it is not met, then it will go on to what? The company will become an unsubscribed, the shares will be unsubscribed, and then the entire issue will be cancelled, unfortunately, unless the underwriters agree to take up the minimum subscription amount. That is why it's very important for the underwriters to be there in the company. Time limit for minimum subscription, very simple. Under Companies Act, it is 30 days from the date of issue, or time limit under SEBI. So predominantly SEBI will take over here. Listed company SEBI. If the issue is underwritten, if it is not underwritten, then the date of disclosure, that is the closing of the subscription list only, before that time you have to get the minimum subscription. What is the minimum subscription? 90%. If issue is not underwritten, assume the issue is not underwritten, then 60 days from the date of closure of the list. That closure of the list is nothing but the subscription list. Whoever has subscribed for the shares, how to ascertain? When I have ascertained that, within 60 days you should do so. That's the thing, very simple. If it is not received within the above limit, application money should be refunded within 15 days, that we already saw. Whereas if the issue is underwritten, mind you, if the issue is underwritten, then the application money should be returned within 10 days. If you don't return within 10 days, interest will be levied at the rate of 15% per annum. 15% per annum is the interest rate. These interest rate, etc., you should remember. It will obviously help us in the examination. Now, collection of application money. How will I collect the application money? Already discussed, guys. Minimum application money under Companies Act is how much? 5% of the nominal value. But I should actually see SEBI. SEBI says minimum you should take 25% of the nominal value. As per Companies Act, as I explained the other time, if the nominal value is 100, as per Companies Act it is rupees 5. As per SEBI it is rupees 25. So what should I consider? Rupees 25. Minimum amount of subscription, it can't be 1000, 2000, 3000 and all. Minimum amount of subscription will be 10,000 rupees. Minimum amount of subscription will be 10,000 rupees. So minimum amount payable will be 25 rupees and minimal 25%, sorry, and minimum amount will be how much? 10,000 rupees. That is how we need to look at it. Return of allotment. Once the shares are allotted, I need to file a return of allotment. Return of allotment. This return of allotment should be filed within 30 days of allotment. Once you allot the shares, within 30 days you have to file a return. With that, you should give the list of allottees, certificate by the signatory, report of the registered valuer, copy of the resolution, everything. And punishment has to be dealt separately. So what are the securities to be dealt in the stock exchange? Every company making a public offer of securities shall make an application to one or more registered recognized stock exchanges. In India, guys, there are only 2 recognized stock exchanges: National Stock Exchange, Bombay Stock Exchange, NSE and BSE. There were many other stock exchanges before. All those stock exchanges got diluted, got closed down after the concept of corporatization and demutualization, which was introduced into the early 2010s, in the early 2000s, right? So that is what everything changed now. Now we have only 2: National Stock Exchange, Bombay Stock Exchange. So can I list it in any of the stock exchanges if I want to? Yes. Answer is yes. If the permission is granted, no problem. If the permission is denied, then I can ask, why have you denied? I want to list in both the stock exchanges. Why have you denied? I can ask all those things. So the deposit of application money should be kept in a separate bank account. It can be utilized for what? Repayment of all the monies and other things. If the Security Appellate Tribunal clearly says that why did you not allot the securities on time, then the full application money has to be refunded. The application money has to be completely refunded. This is securities to be dealt in stock exchange. The word securities, what is the definition of securities? Anything as per Securities Contract Regulation Act, which includes equity shares, preference shares, then debentures, mutual funds, anything that you can think of will be given in SCRA under securities. So can the company apply to any of the stock exchanges? One of the guys asking a question. Yes, you can apply to any of the stock exchanges. That's what I told you now. That is as per section number 40. Coming to underwriting commission. What is underwriting commission? Is an agreement with or without conditions that securities, when the existing shareholder does not buy, then the underwriter will pick it up. But the commission is how much, guys? 5% of the issue price of the equity or preference shares or amount as mentioned in the articles. For debentures it is 2.5%. For equity shareholders and preference shareholders it is 5%. For equity shareholders and preference shareholders it is 5%. And for debenture holders it is 2.5% of the issue size. That's the thing. It is 5% or amount in the articles whichever is less. This is very, very important. Many 4 marks questions have been asked in this. Many 4 mark questions. So please, remember this percentage. For shares, how much is it? Equity and preference, 5% of the issue price or rate authorized by the articles, whichever is less. Whichever is less. And for debentures, it is what? 2.5% or rate authorized, whichever is less. So for one, it is 5% or rate authorized, whichever is less. For debentures, it is 2.5% or rate authorized, whichever is less. That's the thing. Or the commission should be paid in cash, kind, lump sum and all these things. That is with respect to what? Rate of commission. Moving on to the concept of GDR, Global Depository Receipts. Though it has been removed from the syllabus, sometimes institute, if they feel that they want to ask that, they can ask. And I don't believe that it has been removed from the syllabus because it will find its way somewhere. GDR, Global Depository Receipt, is a concept where it is not a share, but just like your commodity trading. Commodity trading is based on the value of gold. You will issue a security. You will issue an instrument. Similarly, based on the value of steel, based on the value of iron, based on the value of silver, like that. Based on the value of a share in the Indian company. For example, based on Infosys share, foreigners can do what? Based on the share value, Infosys share, foreigners can apply for the shares. But can they buy shares in Indian company? Rather than that, we have the concept of GDR, Global Depository Receipts. So in that, what happens? In India, there will be an Indian company and there will be an Indian bank. There will be an Indian bank. And there will be a foreign company and a foreign bank. Or rather than foreign company, let me say, this is the stock exchange there. Now, if Infosys shares wants to be listed abroad, let's say in the New York Stock Exchange, then they will hand over the shares to this bank in Indian company. This is called as a custodian bank. It will be handed over to the custodian bank. Custodian bank will now have a agreement with the foreign bank. Based on the value of Infosys shares given with the custodian bank, a security receipt, a depository receipt is created, and the foreigners can trade in that depository receipt. The moment the value of the shares go up, the depository receipt value also goes up. The moment the value of the shares decreases, depository receipt also decreases. Very, very simple. So as and when the value increases, depository also value increases. When the value of the shares decreases, depository value also decreases. So this concept is called GDR, Global Depository Receipt. So if I want to buy shares, if Americans want to buy shares in Indian company, that is called American Depository Receipts. As simple as that. If, for example, the reverse case, if Infosys wants to buy a share in Tesla, then that is called as Indian Depository Receipt. Indian Depository Receipt. As simple as that. Then GDR. So Global Depository Receipt means any instruction in the form of a depository receipt by whatever name called is what they say. If eligible, I have to go with the FEMA regulation. As you can see, what all I should do. First, they can ask you the 4-mark question as to what are the procedures when I am doing the depository receipts. First one, board of directors should pass a board resolution. Prior approval of shareholders has to be taken by a special resolution. Deposit receipts shall be issued by overseas depository bank. As I told you, one bank is overseas, one bank is custodian, appointed by the company. Underlying shares, Infosys shares will be kept where? In a custodian bank in India. Manner and form, so the depository receipts can be by way of public offering, or it can be by way of a private placement in an overseas listing or a trading platform. On a stock exchange you can trade. It can also be issued against the new securities. Can the people who have the depository receipts, do they have the voting power? No. It is only based on the share value as such. They do not have any power to vote. Voting power not there, guys. So that's the thing. Voting rights, as you see, holder of depository receipts shall be entitled to vote only on the conversion of the depository receipts into underlying shares. Only while conversion and nothing else. Right? That's the thing. Proceeds of the issue, what will you do? The moment you sell the shares, sell the depository receipt, what happens? It will be remitted to the Indian bank. It will be deposited in the Indian bank abroad also, or it will be deposited in any bank, the foreign company. Ultimately, the proceeds of the sale of such depository receipts will be going to the respective account of the shareholders. Very, very simple. So, offer document is needed. That offer document, it will not be treated as a prospectus as such. It is only to a certain group of people. Very, very simple. One more interesting concept that has come, which again regularly will be asked in the exam for 4 to 6 marks, is the concept of private placement. We will discuss that, private placement. Yes. So, this is the next part, private placement. So, what do you mean by private placement? Any offer of securities to a selected group of persons, which the company other than by way of public offer. I don't want to give the shares to the public. I want to choose a few people and give the shares only to those few people, and that is called as private placement. Other than by way of public offer, through issue of something called as PPOL, private placement offer letter. This will be done in form number PAS4. So through PAS4, whatever I give to the private placement offer letter, that is called as private placement. It should satisfy all the conditions given under section 42. Now, what are the limits? Maximum I can give it to 200 people. Private placement offer letter maximum can be given to 200 people in the aggregate. Excluding two types of people. One is QIB, qualified institutional buyers. If I privately place my shares to big shots, they are called as qualified institutional buyers. So QIB, no problem. And then ESOP, employee stock option plan. If I am issuing shares to the employees as in the form of employee stock option, then I no need to fulfill what? The concept of private placement. Private placement is only for whom, guys? Other than QIB or ESOP. QIB, ESOP, there is no limit of 200. I can give it to any number of people. So 200 will be calculated individually for each kind of security. That is for equity shares separate, preference shares separate, and all those things. It will be for different type of security. Value of such offer or invitation per person shall be an investment of at least 20,000 rupees face value. Value of such offer or invitation, how much, guys? 20,000 face value of the securities. 20,000 rupees face value of the securities. Company will keep all the details of each investor in the bank account. Joint holders. Joint holders will be taken as 1. Money shall be payable to the person whose name appears first. Very, very simple. That's the thing. Prior approval. Now, before doing a private placement, I need to take prior approval via special resolution. We have already discussed what is special resolution now, nothing to worry. It is required from shareholders for proposed offer, plus an attached explanatory statement must be given. It contains the entire basis for the price. Entire basis for the price. I should tell why I am privately placing, what is the amount of shares, what is the total amount to be collected, and why am I giving at that price. That has to be given. If offer is for non-convertible debentures, it is enough if the company passes special resolution for 1 full year. For equity shareholders, you have to pass before each resolution, before each disbursement of this private placement, before each private placement I have to do. But for non-convertible debentures, it is enough if the company passes special resolution for the entire year. So no offer or fresh invitation shall be made unless the allotment of any earlier offer or invitation have been completed or abandoned by the company. So the old private placement is still pending. Can I make a new private placement? No. The new private placement shall be made only if the old private placement is over. This revision session is for CA Inter students, old syllabus, new syllabus. CS executive students also can do it. CMA Inter students also can do it. So it's for everybody, do not worry. CS executive, you can do this also, and also my CA final revision, because CS executive is both CA Inter plus CA final. So this is applicable for CA Inter old and new, CMA Inter old and new if any, CS executive old and new if any. This company law will never change, it will remain the same. Next, time limit for allotment of security. Time limit for allotment of security is how much? A company may make an offer, allot the securities within how many days? Ultimately 60 days. From the date of receipt of application. If you do not receive the application, then within 15 days from the completion of 60 days, you need to refund. This is for everyone for that matter, not just private placement as such, for generally. Generally, time limit for allotment or refund of subscription money is when? Within 15 days you need to refund. If you don't do that, 60 days, 60 days you have to pay. If you do not pay, within 15 days you have to refund. Now, from the 76th day onwards, 60 days over, then 15 days. From the 76th day onwards, how much is the interest per annum? 12%. It will be for 12% from the expiry of the 16th day. Right? That is the thing. Very, very simple. Next. Subscription money to be kept in a separate bank account. It will be used only for allotment of securities or repayment, or if unable to allot securities. Very, very simple. That is a normal thing. This is with respect to private placement and also time limit for allotment or subscription of securities. Private placement will only be done to those people to whom I have sent a PPOL, private placement offer letter, prior to invitation to subscribe. Prior to invitation to subscribe. Complete information about such offer to be filed to ROC within a period of 30 days of circulation of relevant private placement offer letter. No company shall directly or indirectly issue any advertisement for offering of any securities as such. So return of allotment in PAS 3, I have to give a return of allotment to ROC within 30 days of allotment. So the form number is PAS 3 within 30 days of allotment with the full name, class of securities, date of allotment, number of securities and all these things. Company shall maintain one more register all the private placement order in PAS 5. Penalty for contravention in all these things is, see the contravention, amount involved in the offer. It can be 5 crore, 6 crore, 7 crore. Amount involved in the offer or 2 crore, whichever is higher. If the amount involved is just 10 lakhs, but you have done a private placement in a wrong way. How much, guys? 10 lakhs or 2 crore? 2 crore. Subscription money also should be refunded within 30 days after imposing the penalty. So this is the entire chapter with respect to the prospectus. So chapter 3, with this we have finished chapter number 3. Got it, buddies? We have completely finished chapter number 3. Done. Now let us move on to chapter number 4. Let us now move on to chapter number 4. Chapter number 4 is what, guys? Share capital debentures. It starts from section 43, it goes to 72. So we are going section wise only, and we are going page number wise. So every day my target is around 17 to 18 pages. That's enough. So then thereby, we can coolly go. There are some chapters which require more explanation. So when we reach those chapters, we will go slower. Some chapters require less explanation, then we are going fast. And mind you, this is not for the ones who have never touched the book. Concepts in class are, taken at a longer duration. For example, now I am doing my CA Inter batch is going on, fresh recording, and even the students are coming online live is also going on. That for the first 2 chapters only we finished, and almost 26 hours we have discussed. Imagine 25-26 hours, first 2 chapters only. So what I am trying to tell is, in the regular class it will be different. Each and every line will be analyzed. This is a pure revision session. So it should be studied also as a pure revision session one day before the exam. So this will be like a all put together 12-hour video. As I told you yesterday, put it at 1.5x or 1.1x, 1.2x speed if need be, or listen in the same speed and then keep on listening to it. If you have my chart book, you can keep on flipping. If you don't have my chart book also, it's okay. Keep on listening to the class. That's it. So it will really help you in the exam, because one day before the exam, this will give you a thorough understanding of the subject. Yes. Next, coming to chapter 4, share capital and debentures. 43 to 72. 43 kinds of shares. There are two types of shares: preference share capital, equity share capital. So we all know that. Preference share capital means what? Equity share capital means what? That is what we need to understand. Very simple. In preference share capital, it carries a preferential right as to dividend and capital. In equity share, obviously, it is a share which has voting rights. Preference shareholders do not have any voting rights as such, unless there is a separate preference shareholders meeting and all those things. Before paying to the equity shareholders, I need to pay to the preference share capital also. As far as preference share capital are concerned, preference share capital are those who participate after any surplus is remaining. Payment is first made to the preference shareholders, and then it is made to the equity shareholders. During the surplus equity and preference, after that, the deemed or participative preference shareholders also will participate in the profits if any surplus is remaining to the equity shareholders. As far as equity share capital is concerned, we have one with voting rights, one with differential rights. Differential rights as to dividend, voting or otherwise. One is with voting rights, one is differential rights. So section 43 does not apply to a private company, where MOA, AOA as the private company may provide, they can do so. So all these respective section kinds of shares, etc., all the provisions will not apply to private company. They can have any number of shares, whatever they want, as simple as that. Nature of shares. Basically, the shares or debentures or any other ownership form as a member of the company shall be a movable property. That is the nature. So basically, shares are also included in the definition of goods under Sale of Goods Act. Share goods are what? Every kind of movable property, but it does not include immovable property. And it also includes stock, shares, etc., which is there. So shares, stock, that is also a kind of shares, and the group of shares is called a stock. That is very much kind of movable property, very much a kind of movable property. That is what you need to understand, right? Next, numbering of shares. Now this numbering of shares is little immaterial, because now everything is become dematerialized. But if it's physical securities, some private companies still have physical securities. For them, you should number them carefully. Numbering is needed. Then share certificate. The share certificate is it a what do you say, document of title or document showing title? Document of title means what? It just gives you the ownership. It shows that you are the owner, and you can transfer the ownership by changing the document of title. Document showing title just shows that you are the owner. Can that be transferred from one person to the other person? Yes. It just shows that you are the owner. Document of title is what? Document of ownership. So a share certificate is prima facie, means on the face of it, evidence of the fact that the person therein is the owner of such shares. Just the owner of shares. Applicability, every company having a share capital is mandatorily required to have a share certificate you should give for sure. Share certificate shall be under the common seal of the company, central government to prescribe the rules, manner of issue of share certificate should be given, issue of duplicate share certificate they will all give, rules will be given for all these things. What if my share certificate is lost? This again can be a 4-mark question. What will be the share certificate if it's lost? Then if I have to prove that my share certificate is lost, if it is defaced, mutilated, torn, defaced means it is torn, it is completely lost its original form. In that case, it's completely mutilated, destroyed. In that case, I can definitely go and obtain a new share certificate. For that, I have to give an affidavit, whereby it's more like that tomorrow if it's like a bond, it's a contract of indemnity, where indemnity bond sort of a thing, whereby if tomorrow if something happens to it, I am hereby indemnifying the company against it. If it's held in the dematerialized form, there is no concept of duplicate share certificate. Whatever in the records of the depository that is there, that is only deemed to be the share certificate. That is only deemed to be the share certificate. Who is this depository, guys? So who is a member? If you see 2 clause 55, member means member is a person, member. Member is a person whose name is entered in the register of members. That is one thing. Second, let's say in an IPO, I have, okay, this is one part. This generally happens in the IPO, already discussed. Second, subscribers to memorandum, they are automatically deemed to be members. Subscribers to memorandum shall be deemed to be members. One is whose name is entered, that is one part. Second, subscribers to memorandum only will be deemed to become members. Third, is what? If it is in the stock market, shares are traded in the stock market, the main person who controls the shares, who has the shares, is called the depository. Depository is NSDL/CDSL, National Securities Depository Limited, Central Depository Services Limited. Under them, there are various banks who can open something called demat accounts. So you have, ICICI Bank, Dena Bank, Vijaya Bank, so many banks are there, HSBC, HDFC, Kotak Bank. Under these, you have various banks. These various banks will open something called as demat account people can open. So if one person transfers shares from ICICI Bank to, let's say, to one more shareholder who holds in HSBC Bank, in the register of members, these names will not change because the depository name will be given. But in the depository's books, these shareholders will be written as beneficial owners. Why will they be written as beneficial owners? Because the benefit will now go to them. The benefit will now go to them. That's why they are called as beneficial owners. The benefit of each and everything, the benefit of each and every provision will go to them. If any dividend is being paid by the company, it will first go to the depository NSDL CDSL. NSDL CDSL will then shift the dividend, everything, to the beneficial owner. That is the concept, right? So that is called depository, CDSL, NSDL. So wherever you are seeing the word depository, 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 always remember it is NSDL/CDSL. NSDL slash CDSL. That is the meaning of wherever you see depository, that is the meaning NSDL, CDSL. Yes. Then time limit. These time limits also can be asked in MCQ. Within 2 months of incorporation, you have to allot to the subscriber of a memorandum. I told you, first guy member. Allotment of normal shares should be done within 2 months of allotment. You need to deliver the certificate. For normal subscribers, within 2 months of incorporation. For those who have allotted shares, within 2 months of allotment, they give the share certificate. Debentures within 6 months. In case of transfer or transmission, within 1 month from the receipt of transfer deed or intimation of transmission. Transfer means sale of shares. Transmission is through what? Death, etc. Transfer, transmission. Transfer is what? Shares. Transfer is what? Shares. Transmission is what? Transmission is different. Transmission is what? A different thing altogether. Transmission means by death or by liquidation or anything. Basically by operation of law. If a person dies, automatically the shares will have to now go to the legal heir. If a person is declared as an insolvent, automatically the share should now go to a liquidator. So by operation of law, when it transfers from one person to the other person, that is called, transfer or transmission. Got it? That's the scene. Time limit for delivery of certificate is what you need to understand. Next, coming to section 47. So guys, this share capital chapter is also very important. Chapter number 4 is very important. Why? Because the same chapter we'll also be using in various other things. This chapter is important because this chapter, for example, if I say buyback of shares or whatever it is, this will also apply to auditing. So in auditing subject, they will ask you, how will you audit, shares? How will you audit issue of bonus shares? How will you audit issue of equity shares? How will you audit issue of, sweat equity shares? So if I know the provisions, if they ask it in law, I just have to write the provisions. But if they ask it in, auditing, we should see that we should check as an auditor whether the company has taken all these into consideration. Like that we need to write. So one is share capital. So this chapter number 4 is very important for auditing. Chapter number 8, 9, 10 is also important for auditing. Chapter number 4 is share capital. Chapter number 8, 9, 10. 8 is dividend, 9 is accounts, 10 is audit. Right? 4 is normal share capital, 8 is dividend, 9 is accounts, 10 is audit. So these things we need to keep in mind. So voting rights of shareholders, voting rights of equity shareholders, and all this we have to see. Equity shareholders shall have the right to vote on every resolution placed before the company. 1 on a poll. The voting right of every equity shareholder shall be in proportion to his share in the equity share of the company. 1 with respect to the poll, 1 with respect to something else. That is what we need to see. Voting rights of preference shareholder. Preference shareholder shall have a right to vote on matters directly affecting their rights, on every resolution for the winding up of the company, and matters for repayment or reduction of share capital. This is only the voting rights, only which directly affect their rights. That is one part. Second, when it comes to the winding up of the company, then they will be there. Third one, matters for repayment or reduction of share capital. Any reduction of share capital in section 66 that happens, automatically I have to take the preference share capital holders view. You would have understood the concept or heard the concept of internal reconstruction. So in internal reconstruction, we have invoked section 66 and I have to take the preference shareholders approval as well. So the voting right of every preference shareholder shall be in proportion to his share in the paid up share capital of the company. It is always generally in a show of hands method, it is one person, one vote. Whereas in a poll method, it is always one share, one vote, right? It is always one share, one vote. Apart from that, you can also, preference shareholders will get the same right as equity shareholders. Preference shareholders will get the same right as equity shareholders in what? In this case, if the dividend on any class of preference shares is not paid for 2 years or more, then every preference shareholder shall have a right to vote on every resolution. If you are a preference shareholder and if you have not paid what? Preference share, if you have not been paid preferential dividend for 2 years or more, if you have not been paid preferential dividend for 2 years or more, then the preference shareholder will now automatically get the right of a equity shareholder. Preference shareholder will get the right of an equity shareholder, and then he has to what? He can vote as if he is a equity shareholder of the company. He can vote as if he is the equity shareholder of the company. The preference shareholder will get the same voting rights as a equity shareholder. That is what we are trying to tell. Preference shareholder will get the same rights, same liabilities, everything as the other guy, as the equity shareholder. Moving on. Just a sec. Let me see. Yes. So hope you are able to see, guys. All good? Yeah. Yeah, generally this is used for cumulative preference shares. Generally it is for cumulative preference shares, but otherwise also it is possible. Generally it is for cumulative preference shares. Moving on. 49. Calls. Calls on shares of same class to be made on uniform basis. So when I make calls on shares, it should be made on shares of same class. It must be uniform. However, shares of the same nominal value on which different amount has been paid up shall not be deemed to be paid under the same class. So I can make call money of equity shares, but if there are, let's say, equity shares of 10 each, 8 paid up, equity shares of 10 each, 5 paid up, and different amounts have been paid up, then they are considered to be different class. You cannot say, sir, both are equity shareholders. No, because the amount paid up is different. Equity shareholders of 10 each, 5 paid up is different from equity shareholders of 10 each, 8 paid up. So since the paid up values are different, the other parts also we need to keep in mind. Value per call. As per table F, calls must not exceed 1/4 of the nominal value of the shares. So basically, if there is 10 rupee share, what is the call that you should not exceed maximum 2.5 rupees? How did 2.5 come? 1/4 of 10 rupees. So how is the call made? Call is made by serving a notice to the payee. And the notice should clearly mention that if you do not pay the call, what will happen, what will not happen, and all these things. That is with respect to voting rights. What about calls in advance? Calls in advance. In that case, it should be authorized by AOA. If the AOA is silent, mind you guys, if the articles of association is silent, then you cannot, I repeat, you cannot take calls in advance. And interest, the company will pay an interest upon the agreed percentage. And what is the interest that you will get generally? Maximum rate of 12% per annum. Maximum rate will be 12% per annum. Otherwise, it is a different thing. Maximum rate 12% per annum. Calls made in advance. There is no extra or special voting power required for the members. They will not get any special voting powers just because they made call in advance. Call in advance is different. If AOA authorizes, then the company can pay dividend in advance money received on calls. The amount received in advance for calls is not refundable. Obviously, you cannot refund that later. This is with respect to section 50. Next is the idea, what about, sir, the face value, dividend. Dividend is paid on face value or is it paid on paid up value is the question. So section 51 gives the answer. It says a company, if so authorized by AOA, may pay dividend in proportion to the amount paid up. Interesting to know that if articles are silent, dividend is always paid on nominal value. But if articles authorize it to the, in the articles it authorizes that it should be paid on paid up, then dividend will be paid on paid up. So one is nominal value, one is paid up value. If articles is silent, dividend is always paid on nominal value. If articles is paid up, then dividend is paid up on the paid up value. As simple as that. Company may, if so authorized by its AOA, pay dividend in proportion to the amount paid upon each share. Can I issue shares at a premium is the question. Before that, can I issue shares at a discount? So important area, section 53, you can never issue shares at a discount. Shares at a discount concept is not right, it is not correct. You cannot issue shares at a discount. How does it work? Like this. Prohibition. A company shall not issue shares at a discount ever, except as what? Sweat equity shares. As sweat equity shares, definitely you can do it. As sweat equity shares, definitely you can do it, but otherwise not possible. So it was Narayan Murthy who in fact went to the MCA and said, look, my employees have been working day in and day out. They have made Infosys one of the best companies in the world. So I want to give shares at a discount. MCA said not possible. So he said, please insert a section where I want to give them shares free of cost. It's not free exactly, they have already earned it. So through their blood and sweat, they have already earned it. That's why the concept of sweat equity shares came into force through section 54. Anything that you have issued at a discount, if you have issued shares at a discount without using the sweat equity route, normal shares at a discount will be void. Any shares issued by the company at a discount will be void. Effect of default is what? You have to pay fine 1 lakh, it will go up to 5 lakh. Every officer of the company, if you see, imprisonment maximum 6 months, or fine, or both. When Act uses the word or, fine or imprisonment, this is called as a compoundable offense. Offense can be compoundable, means what? You can escape imprisonment by paying fine. But if you remember in section 447, they use the word fine and imprisonment. This is called as a non-compoundable offense. Can you escape imprisonment by paying fine? No. We cannot escape imprisonment by paying fine. This is a different thing. One, you can escape imprisonment by paying fine. One more, you cannot escape imprisonment by paying fine. Issue of shares at a premium. Yes, you can definitely issue shares at a premium. So what is it? Premium refers to the excess of the share issue price over its face value or the par value. For example, if the share of face value of 10 rupees issued at 120 rupees, then there is a premium of 110 rupees per share. Share can be issued as a premium, which may be received either in cash or kind also, doesn't matter. When any premium, where will it go? It goes to the account called as securities premium account. Rate of premium is decided by the board of directors. Under SEBI, you should have a proper justification as to why you are charging a premium. Most important question regularly asked for 4 marks. What are the applications of the securities premium account? We need to understand that securities premium is nothing but a quasi capital. Means what? It is like a capital only. Basically the share price will be 10, but you are charging a premium of 100 more. This 100 more is the extra capital that you are getting. So obviously you can use this capital only to knock off capital. What are the other forms of capital? One is what? Issue fully paid bonus shares. Second one is what? Write off preliminary expenses of the company. Preliminary expenses are on the asset side. Why? Because these are the expenses required to start the company. So that's why they have moved it to the asset side, though it is an expense, it is on the asset side of the balance sheet, because the benefit will accrue over the future for all these expenses that you have incurred. Then writing off of expenses incurred, commission on commission paid and discount allowed on shares. Again, these things, the benefit will accrue in future. So all the commission paid provisions you need to write off. Providing for premium payable on redemption of any redeemable preference shares. When I am redeeming preference shares, if I am redeeming it at a premium, that is also quasi capital. So one quasi capital can knock off one more quasi capital. This is with respect to preference shares. One more is with respect to equity share, that is buyback of securities under section 68. So if you see, this section will, creation of security premium account is a quasi capital. I will use this security premium account to also write off capital. So 2 related to buyback, 2 related to expenses, and 1 of course the bonus shares. Very important 4 mark question regularly asked in the examination, right? So that is with respect to the issue of securities premium account, shares with premium. Next, coming to sweat equity. Sweat equity. Always remember guys, whenever the company is issuing shares, it comes under section 179(3). 179(3) is a section where they say that power to borrow money, power to invest funds, power to make calls, power to issue securities, everything is only vested with the board of directors through a board meeting resolution. So through a board meeting resolution only it can do. Can it be delegated to somebody else? Yes, it can be delegated to another party. Who's another party? It can be delegated to managing director, whole-time director, manager, all that is okay. It can be delegated to the principal officer, that is the branch head. They can also make the, they can also issue securities, they can also borrow money, they can also, invest funds, they can also grant loans, no problem. But predominantly it is done by the board only through a board meeting resolution. So whenever any question is being asked with respect to issue of securities, we need to write this line. Board meeting resolution. We need to write the line board meeting resolution without fail, right? So if you see anywhere, you have to write board meeting resolution. So if you see there, section section 54, 2 clause 88 defines sweat equity shares. Sweat equity shares is for the sweat or the blood given by the employees. So sweat equity means equity shares issued by the company to its employees or directors at a discount or for a consideration other than cash. Either at a discount or for a consideration other than cash. And for providing know-how, intellectual property rights, value additions and all these things. It is always at a discount or for consideration other than cash. And it will also provide what? Technical know-how, intellectual property rights and also value addition. You have provided the value addition, you have provided intellectual property, the least I can give is give you shares. Who is an employee? Employee can be a permanent employee of the company who is in India or outside India. An employee can be a director of the company, whether whole time or not whole time. An employee or a director of the above, not only that company but also the subsidiary company or the holding company, whether in India or outside India. All these people are defined under employee. Next. Second, it went off behind. Then company can issue sweat equity shares only after 1 year from the date on which it has commenced business. So no company can issue sweat equity before 1 year, minimum 1 year time you have to give. Sweat equity shares must be of a class already issued by the company. If you have already issued equity shares of a certain class, same thing you have to, similar thing you have to do. You cannot issue shares, securities which is already not issued before. Holders of sweat equity shares shall rank pari passu, means on equal footing, equal proportion with other equity shareholders. Just because you have got the shares without paying any money doesn't mean you are any less compared to the equity shareholders. Both of you are equal is what they are trying to tell. Now, apart from issuing, for issuing I already told you guys it requires board meeting resolution. Apart from that, it should also be authorized by what? A special resolution. Shall be authorized by passing a special resolution. With respect to what? Should have the number of shares, current market price, consideration if any, classes of directors, employees to which such shares are issued, and all these things. And then sweat equity shares for a listed company, I have to blindly follow SEBI guidelines. For an unlisted company, I should follow the company share capital and debenture rules. For unlisted company, it's very simple. Notice of general meeting shall be given for every item of special business. Now very simple guys, what are ordinary businesses? Adda points or dada points. Dada points happening at AGM is called ordinary business. Other things are called special business. Issue of sweat equity shares, whether it happens at AGM or EGM, mind you, is always a special business. No doubt about it. Always special business. Hence, so notice of general meeting contains explanatory statement which contains about the date of the board meeting, total number of shares to be issued as sweat equity shares, name of the directors or employees, time period of association of such persons with the company, price at which the thing is issued. Everything should be kept in mind. What is the time of allotment? Within 12 months from the date of passing special resolution, I need to allot the sweat equity shares, whichever is, that's the thing. Here, it is what? Here, coming back to this, ceiling limit on sweat equity shares. Ceiling limit. Annual limit maximum 5 crore or 15% of existing paid up capital, whichever is higher. Per annum, I can issue maximum 5 crore or 15% of existing PUC. So if this thing is 100 crore, I can either give 5 crore or 15 crore, whichever is higher. So 15 crore I can give, very simple. Overall limit, the total issuance of sweat equity at any point of time shall not exceed 25% of the paid up equity capital of the company. Which means if the capital of the company is 100, maximum ever at any point of time should be maximum 25 crore. If last year if I have issued 10 crore, this year I am issuing 10 crore, next year, assuming the paid up capital remains the same, next year it can only be maximum 5, because overall it cannot exceed 25 crores. That's what they are trying to tell. Apart from that, other regulations, There will be a lock-in period. The sweat equity that you have purchased or you have got will be locked in for 3 years from the date of allotment. Otherwise, what will happen, guys? Today you give me sweat equity, tomorrow I will sell it off. Imagine you give me 20% worth of sweat equity, tomorrow I will sell it off. If I sell 20% in the open market, what happens is the share prices will reduce. People will create panic. People will like, everybody is selling, let me also sell. Why will you sell? Thinking that the share prices will reduce in the future. So that's why there is a locking period of 3 years. And the valuation of shares, it is mandatorily be done by a registered valuer. Registration of sweat equity shares in form number SH3. That's the final registration of sweat equity shares. So this is with respect to the types of shares and all those things. Now we will take a short break, right? Because I've been having class from morning, guys, 6 a.m. I've had absolutely no break, so I need a 10-minute breather. You also take a breather. It's the correct time because we have finished around 1 or 20 minutes. So let's take a break and get back. Then we will be discussing this. So the target is very simple, 18 pages a day. 18 to 20 pages we have to do because we have around 70 pages. So today let's try to finish more. Let's try to finish around 20 pages. Okay. So we will come back very soon. 10 minutes is the break. See you in 10 minutes, buddies. I hope you are able to understand. Good that many of you are attending it live, because though you may see later and all those things, attending live, the charm is different. You are sitting in front of me, I mean, of course, virtually, and you are attending the session, so that revision is happening at your end also. Okay. On that note, let's take a break. See you soon. All right, buddies, let's begin. Hope you took a short break. Okay, so let's continue. So we are done with which section? We are done with the entire concept of section 54, sweat equity shares. Moving on, now we will do a concept of issue and redemption of preference shares. This is also a very, very important concept. One thing very interesting in issue and redemption of preference shares is that the entire redemption and issue, whatever it is, has to be authorized by the articles. If it is not authorized by the articles, means if the articles are silent, then you can never issue preference shares. So you can never issue preference shares if you do not authorize by the articles. So what are the basic condition of the preference share issue? A company limited by shares can issue preference shares only if the AOA authorizes it. Only if the AOA authorizes. If the AOA does not authorize, you cannot do it. If the AOA is silent, can you issue preference share capital? Never. So the articles of association should authorize the preference share. Second one, I need to pass a special resolution. I need to pass a special resolution. Special resolution means what? It has to be, first of all, notice has to be given. In the notice, you have to mention that the intended resolution is special. Third one, the votes cast in favor must be 3/4 majority. Those three things have to be followed without fail, right? Three things have to be followed without fail. Then, at the time of issue of preference shares capital, the company has no subsisting default. There should not be any default while issuing preference share capital. In the what? First of all, there should be no default in payment of dividend due for any preference shares. Second one, there should not be in the redemption of preference share capital either before or after the commencement of the act. If you have failed to redeem preference shares before, can you now issue new preference shares? No. Second, if you have failed to pay dividend on preference shares before, can you issue new preference shares today? No. That is what they are trying to tell. in the redemption of preference shares or in the payment of dividend due, there should not be any default, right? There should not be any default. You just change again, I think it's absolutely fine here. Yeah, there should not be any default. Next, time period of redemption. Very interesting to know that the maximum time period for redemption is how many years, guys? As per the law, 20 years. Can you issue preference shares beyond 20 years? No. You can issue redeemable preference shares maximum 20 years. Maximum 20 years. Beyond that it is not possible. It should be maximum 20 years. So, but for infrastructure facilities, it can go up to 30 years. Infrastructure. Sir, what do you mean by infrastructure companies? That is given here. Transportation, road, rail, system, port, agriculture, storage, quality, testing facility, water management, water supply, distribution, then telecommunication based on cellular, broadband, etc., power generation, petroleum, natural gas, housing. These are called as infrastructure projects. So if you are at a company which is building these infrastructure projects, then what is the number of years that is needed? 30 years. Then you have to go for 30 years. So minimum 10% of such preference shares should be redeemed every year from the 21st year onwards or earlier on a proportionate basis. Means what? From the 21st year onwards you need to start redeeming. So that is what they are trying to tell, on a proportionate basis. At the option of the preference shareholder, you can do so. This is for the infrastructure facility. For 20 years, no problem. For the 21st year onwards, what should you do? You have to start redeeming the thing. Maximum 20 years. For the infrastructure facilities, 30 years. No, that's why. At the option of the preference shareholder. Now, what are the other things? The day you, issue the preference shares, what all will happen? You have to issue redeemable preference share only, obviously. How will you redeem it? A company may redeem its preference shares only on the following terms on which it was issued, first of all. And if the terms and conditions were varied during the course of the 20 years, whatever it is, then you should ensure that the rights and duties and the rights are not affected under section 48. Voting rights should not be affected in any way. Now, only fully paid up bonus shares can be redeemed. Only fully paid bonus shares can be redeemed. When you redeem, for example, if you just see numerically, you have equity share capital some amount, preference share capital some amount. Now I am redeeming the preference share capital. When I am redeeming the preference share capital, I can either issue new share capital. So it can be equity or preference. So new share capital will come, old will go. So 10 crore worth of new will come, 10 crore will go. Then the capital balance, the capital base will be the same, no problem. One more option available to you is equity share capital is there, preference share capital is there. Preference share capital 10 crore you are redeeming, but you are using the general reserve of the company to redeem. When you use the general reserve of the company to redeem, earlier it was both equity share and preference share. Unfortunately, now it is only equity share capital. The capital base is changing. Capital base is changing. So to ensure that the capital base does not change, we have to create a account called capital redemption reserve account. If we are touching the general reserves, if we are touching the general reserve or the P&L account to redeem the preference shares, I also need to take an equal amount from the general reserve and make it into CRR. CRR is a quasi capital, means it resembles the capital. So now what happens is we have equity share capital and we have CRR worth 10 CR. Basically the capital base remains the same. Capital base remains the same. Got it? So CRR is needed when I touch my general reserve. CRR is needed when I touch my general reserve. So if you see here, on only fully paid shares can be redeemed. What will be the sources of redemption? Preference shares can be redeemed only out of divisible profits, or out of the proceeds of fresh issue of shares made for the purpose of redemption. It can only be used out of divisible profits, that is one. One more is what? Proceeds of fresh issue of shares made for the purpose of redemption. Notice will be given within 30 days of redemption. Notice will be given. The moment you redeem, within 30 days you have to give the notice. If you touch the divisible profits, then I should also create a account called Capital Redemption Reserve Account. Capital Redemption Reserve Account. So transfer of CRR of a sum equal to the nominal amount of the shares redeemed should be transferred out of divisible profits to Capital Redemption Reserve Account. Those of you are feeling the video is blur, here it's coming absolutely fine. Please change the quality. There, go below to the settings, change the quality to 720p or 360p. You are probably looking at 144p. That's the reason why you are getting it blurry. Check your internet connection, right? That's the thing. Then notice of ROC should be given within 30 days of redemption. All that we need to keep in account. Now, provision of the act relating to the reduction of share capital shall apply to CRR. The same will apply to CRR also, as if CRR were to be the paid capital of the company. As if CRR were to be the capital of the company. So basically, the same thing. CRR is like a quasi capital. CRR is like a quasi capital. The same thing will come. Quasi capital. Next. Effect of failure to redeem preference share capital or to pay dividend. What happens if you do not pay dividend? I basically 10 crore worth of preference share capital was not redeemed. Can I issue now? Can I convert this into a fresh issue and give it to the same people? Yes. The company may issue further redeemable preference shares equal to the amount due. Same amount due, including dividend equal to the holders. One second, this page number just got changed. Yes, the company may issue further redeemable preference shares equal to the amount due, including the dividend equal to the holders of 3/4 in value of such preference share holders. 3/4 in values in the value of such preference shareholders and NCLT approval. So, if I have not paid, for example, 10 crore worth of preference share capital, if I have not redeemed, I can now make a further redeemable preference share of the same 10 crore, but whose approval is to be taken? 3/4. Sir, what about the 1/4 who have dissented? The 1/4 who have not agreed are called as dissenting shareholders. So basically, if 10 crore is not redeemed, I have to redeem the full 10 crore, or I can request the shareholders, preference shareholders, look boss, can I again reissue, adding this plus dividend plus interest, everything added, can I reissue this? If 3/4 in value agree, only then it can be reissued. But there can be remaining 1/4 do not agree. The remaining 1/4 do not agree are called dissenting shareholders. For dissenting shareholders, the law says you have to repay immediately. You need to repay them immediately, no waiting for later. That is with respect to this. Coming to section 57, it's the same, guys. It is similar to 447 there, but here if you impersonate a shareholder and if you try to obtain any shares, means if you think, though you are not a shareholder, you obtain some fake documents, fake KYC, and go and tell that you are the shareholder, then you will be punishable 1 to 3 years and fine of 1 to 5 lakhs. In addition to it, if fraud is proven, then you will also be liable under section 447, the dangerous section that we have already seen. You will be liable under section 447 also. That is also very important. You will be liable anyway under section 447. Now, as far as loss of share certificate, if I lose share certificate, I already told you, first of all, you can apply for a duplicate share certificate. Then you should take the prior consent of the board of directors and all relevant supporting evidence has to be carried forward, and then you have to take, as I already told you, an indemnity bond. Indemnity bond is for the company, protecting the company, that where you will tell, I was the owner of the share certificate, I was the owner of the shares, I have genuinely lost the share certificate, I am sorry, I have genuinely lost the share certificate. So tomorrow if anybody comes and tells that he is the owner, so I am telling the company, look boss, don't worry, I am only the owner. If tomorrow somebody else is coming and telling he is the owner of, he as the share certificate, I will indemnify you, I will compensate you. That is called as indemnity bond. Indemnity bond has to be given. So it is for what? Unlisted company, it is to be done within 3 months. For listed company, it should be done within 45 days. Unlisted company within 3 months, listed company should be done within 45 days. Then you need to also maintain a register for the duplicate share certificate. This will be under form number SH2, register for duplicate share certificate. That's the thing. Next, what else is there? Can I transfer shares to a minor? So since minor is not a person and incompetent to contract, you cannot give a share to a minor. Nevertheless, points to add on, minor can hold shares in a company. Minor can hold shares in a company. In which company? Minor can definitely hold shares in a company in which the shares are fully paid up. If the shares are fully paid up, definitely the minor can hold shares in a company without doubt. No tension, can hold shares in the company. Fully paid up shares. That is point number 1. Point number 2, he should be supported by a legal guardian. A guardian must always be there. Only then minor can hand over the shares. That is with respect to fully paid up shares. Next part, buddies, is the concept of transfer and transmission. Transfer is to transfer the shares from one person to another person. Transmission is, I told you, operation of law. Death, disqualification, insanity, any of these reasons. So section 44 talks about shares or debentures of a company shall be a movable property. We know that. Section 58, securities and other interest of any company shall be freely transferable. For a public company, it shall be freely transferable. For a private company, the transfer will be restricted. As we already know, the definition of private company restrict the right to transfer shares. So it will not be prohibited, but it will be restricted. As far as the instrument of transfer is concerned, that is form number SH4. The transfer shall be duly stamped, dated and executed by the transferor and the transferee. The transfer form will be delivered to the company within 60 days from the date of execution, along with the share certificate and all those things. Then company shall not register the shares if application is made by the transferor alone. Basically, transferor and transferee both have to make the application, sign the application. The form number is SH5. Guys, all these things are irrelevant now, because at the click of a button you can transfer the shares. Everything is happening electronically in the DMAT form. But this is predominantly applicable to those companies where DMAT is not applicable. So I need to give NOC within 2 weeks from the date of the receipt of the notice, you see here. In case of depository, the company will directly intimate the depository, no tension. That is a no problem for them. That is very, very simple. Transfer of security by legal heir, it is valid. For that, you should give a proper will and a nomination certificate to tell that this is what is done. If in case the company refuses to register the transfer, so I am, my great grandfather left some shares for me, I will go to the company and say, look sir, this is the will, this is a nomination certificate. They refuse to transfer without sufficient cause. They will not give me any reason. They refuse to transfer. Now, can I sue them? Yes, that is section 58. Definitely within 30 days I can prefer an appeal to the tribunal, and first of all 30 days I have to give it to them, where they will change my name, put my name in place of the old person's name. But if they refuse to do so, then I will appeal to the tribunal within 60 days of refusal. Within 60 days of refusal I will do so. On the other hand, if it's a private company, same thing. I will intimate within 30 days by the company to the transferor and transferee, and I can prefer an appeal within 30 days. So this 30 days basically for private company, it is 30 days and 60 days. If the company has intimated to the transferor and transferee, I can appeal within 30 days. If they have not intimated, I will appeal within 60 days. This 30 and 60 is replaced by 60 and 90 for public company. That's all. If the company has intimated within 30 days, then appeal within 60 days. The company has not intimated within 30, then it is 90 days. So 30 and 60 is replaced by 60 and 90. 30 and 60 is replaced by 60 and 90. As simple as that. Now tribunal, after hearing all the parties, may either dismiss the appeal or they may pass an order, is what they say. Imprisonment, all the other things will come. So publication of the authorized or subscribed paid up capital, etc. I have to give a notice, I have to give an advertisement, business letter shall be given, and all these things will be there. Now another interesting part of the entire law is section 61, which talks about the power of the company to alter the share capital. Power of the company to alter the share capital. So a limited company having a share capital may, if so authorized by the articles. This we have already seen, guys. This we saw in the MOA. Change of MOA, we have change of name clause, situation clause, objects clause, liability clause, then capital clause. This capital clause is section 61. If I want to alter the capital, it is always an ordinary resolution. Why? Because in section 13 it clearly says that if you want to amend the article, save as otherwise provided in section 61. In all other cases special resolution, for section 61 it is ordinary resolution. So it has to be an ordinary resolution, is what they say. Increased in authorized capital, consolidate and divide, subdivided shares, and all these things. Which we have already seen yesterday when I did the concept of MOA. Very, very simple. Now, one more interesting area is called as reduction of share capital under section 66. Now, reduction can be without the approval of the court, or reduction can be with the approval of the court. If it is without the approval of the court, it is normal surrender of shares or forfeiture of shares. Surrender or forfeiture. Forfeiture means what? If I am unable to pay some call money, etc., they will only cancel the shares. How will I cancel? They will give me a notice of forfeiture. It should be part of the AOA. They will give me notice of forfeiture. That notice will generally be around 14-day notice. If I do not pay the call money, shares will be forfeited. The forfeited shares can be resold at the open market or resold by the company as they deem fit. Surrender is, I cannot pay. So voluntarily you don't have to cancel. I am only coming and surrendering. That is called surrender of the shares that may or may not be accepted. But the real reduction, dear friends, is section 66. Reduction of shares with the approval of the court under section 66. It's a very, very important area. So what will they do with the approval of the court? Very, very simple. So in that case, what will they do? The full procedure of section 66 have to be followed, where the reduction of share capital will go through the NCLT mechanism. I have to apply to the National Company Law Tribunal. They will see why I am changing, why I am reducing, and all those things. Reduction of share capital is nothing but the internal reconstruction that you have studied in accounts, advanced accounts. I think it's there in your advanced accounts or accounts, one of the subjects, either accounts or advanced accounts. Internal reconstruction, whereby it can also be like a compromise or arrangement. Compromise or arrangement, where you will make an arrangement with the shareholders and with the creditors, requesting them for some mutual concession. Mutual concession. So basically, apart from the board resolution, you should also approve the scheme, and this scheme will be as per the valuation report, and most importantly NCLT approval is needed. NCLT will check whether it is done, not done, all these things. So same way you need to take this into account. That is with respect to reduction of share capital under section 66. Now, moving to further issue of share capital, we'll come back to section 66 in a while. Moving to section 62, this is further issue of share capital. Further issue of shares. Further issue of shares means what? Section 1A, 1B, 1C. Further issue. Further issue can be a right issue, employee stock option plan, or issue of shares on preferential basis. Right issue is 62(1)(a), right issue. 62(1)(b). 62(1)(b) is a different thing, employee stock option plan, and then also we have preferential issue, 62(1)(c). Then we also have the preferential issue, 62(1)(c). That is what they are trying to tell. 62(1)(a), 62(1)(b), 62(1)(c). Now, what do you mean by right issue? Right issue shall be offered to the existing shareholders. Right issue shall be offered to the existing shareholders. In what way? Very simple. This was the biggest right issue that happened by Reliance, guys. Reliance Industries. Biggest right issue that happened, Reliance Industries. So, what was the thing that happened in Reliance Industries? The biggest right issue that happened was, for every 15 shares in Reliance, you would get 1 share. Is it necessary to remember section numbers? I already told you yesterday. No need to remember any section numbers. If you can remember, great. Otherwise, leave it. No problem. But never ever write the wrong section number. In a right issue, what happens? 15 sham companies, correct? Sorry, 15, so what am I saying? Very sorry. Sham companies, I went off to the layers of investment companies. Sorry, my bad. So I'm talking about right shares. Existing shareholders, if you have existing shareholders, first I need to offer shares to them as a matter of right. Because first you need to convince the people who are inside the company, then you can go outside. One thing you need to understand, buddies, that right shares is always a benefit. Right shares is always a benefit given to the existing shareholders. So I will first give right shares to the existing shareholders. In Reliance, shareholder 15 share, if you had 15 shares, you would be eligible to buy 1 shares. So in Reliance case, some 1,600 people. The share price was 1,600 rupees, but they offered it to the people at 1,300. Definitely there was a benefit, because this was as per the valuation. Now, what are all the various conditions of the right issue? Right issue shall be offered to the existing shareholders only. Shareholders to receive invitation to offer to the shares of the company being offered to others. This is called right of preemption or preemptive right. Shares shall be offered to the existing shareholders without fail in proportion to the paid up share capital of the shares held by them. In proportion to the paid up share capital. There has to be a letter of offer. Rights offers can be made by way of a letter of offer. The letter of offer shall clearly say that this is the time limit given. Let's say around minimum 15 days, maximum 30 days. Within this minimum 15, maximum 30, if you do not apply, then I can say that it has been declined, which means I can now sell that right to somebody else. Now let us say I have a right, for example, 1,600 worth of shares, I got it at 1,300. Can the shareholder now sell this right? Definitely he can sell this right to somebody else. He can definitely sell this right to somebody else. So 300 to 1,600, he can sell this right, let's say, for 100 rupees to somebody. Correct? So 100 rupees I can sell this share to somebody else. So basically 1,300 plus 100. A person who is purchasing the right shares is now paying 1,400 as against the market value of 1,600. As against the market value of 1,600. This is what they are trying to tell. Next, what are the conditions? The basis of the offer should be the paid up share capital and all those things. Letter of offer. Right offer can be made by way of letter of offer. The content of the offer, as I told you, the entire thing, minimum 30 days, minimum 15 days, maximum 30 days from the date of the offer. That's it. Then Manner of sending notice. It should be dispatched to the existing shareholders at least 3 days before the opening of the issue. Either through registered post or speed post or electronic mode. I need to send it to them, all of them, minimum, 3 days before the offer. Non-acceptance of right. So the board of directors may dispose of the shares in a manner beneficial to the company if you do not accept the shares. First I will offer to you. If you say no, then I'll offer to the other people, outsiders. That is the concept of right shares. Very, very simple. Next concept we will go. Yes, 62(1)(a) is right shares. 62(1)(b) is ESOP, Employee Stock Option Plan. This is different from sweat equity, guys. Sweat equity shares, this is for the work that you have already done. Today I am offering shares, either at a lesser value or free. Employee stock option plan is an option given to you to buy the shares at a future date. 2 years later, 3 years later. 2 years later, 3 years later, you have to stick around in the company. This is like a benefit given to people who want to stay long term in the company. You stay for 2 years in the company. After 2 years, I will hand over the shares to you, right? So you have an option to buy the shares at a lesser value. So this period of 2 years that I told you, whatever, is called as the vesting period. During the vesting period, what will happen? You will be in a position to, employee will be in a position to bargain later where he can purchase the shares 2 years later. But what is the benefit for the company? That this employee will stick around. If he wants ownership in the company, that number of shares that I am giving him a sizable number at a discounted value, then he has to stay in the company for minimum 2 years. So that vesting period is called waiting period. At the end of the waiting period, you will get your shares, as simple as that. Now, the company may by a special resolution vary the terms of the ESOP. Such variation should not be prejudicial. This ESOP, again, any granting of securities, whatever it is, should go through a board resolution. Vesting of company's employee stock option plan, this is non-transferable. The option granted to employees cannot be transferred to somebody else. He cannot say, sir, I don't want the option, I will transfer to somebody else. Right shares can be transferred. I have a right to buy the shares, that right I will transfer to somebody else. But ESOP, the right to purchase shares at a future date, cannot be transferred to somebody else because only that person I am giving. Exception can be what, guys? Death of an employee. You were there in the vesting period 2 years, at the end of 2 years you died. So the board of directors may say, no, he actually fulfilled his side of the bargain. Now let us offer the shares to his legal heir. Let us offer the shares to his son, daughter, wife, parents, whatever it is. That is called, exception to the rule. The option granted to the employee shall not be pledged, hypothecated, mortgaged. Now, this fellow, you have promised me as a company to pay me 2 crore worth of shares. I can buy later. Today, can I take that 2 crore, go and tell Sir Caesar, I have a right to purchase 2 crore in 2 years. Give me loan on that. No. It cannot be pledged, hypothecation, mortgage, nothing can be done. That's what they're trying to tell. Registration or termination of the employee, all options not vested by the employee as on that date shall definitely expire. It will expire. As far as the director's report disclosure is concerned, options that are granted, options that are vested, everything you should give. Options exercised, total number of shares, options lapsed, exercise price, everything I should give to the company. Registration of ESOP also, it should be maintained at the company's registered office, contains the particulars, everything, all that should be done. Now comes preferential basis. Preferential basis again is a form of private placement where I will handpick a few people and give them the shares. The difference between 42 and 62 is 42 different set of rules have to be followed, and 62 different set of rules have to be followed. Preferential offer is a form of private placement for sure. So means an issue of shares or securities of the company to any select group of persons on a preferential basis. This does not include public issue, right issue, ESOP, sweat equity, or any depository receipt in case of GDR. All these are different concepts that we are understanding. Here it's a different concept. That's what they're trying to tell. So what are the conditions? AOA should authorize it. You should pass a special resolution. Securities must be fully paid up. An allotment of security should be completed within 12 months from the date of passing the special resolution. Same. Similar points to 42, but here there are different procedure. Valuation report is needed of a registered valuer. A registered valuer's report is a must. Price of shares will be given. Price of the resultant shares were convertible securities that should be taken. Valuation, I have to maintain the valuation possibly. Everything should be maintained carefully. That's what they're trying to tell. Then what else does it say apart from all these things? Valuation report also have to be followed. Preferential offer, conditions, all that done. Apart from this, the next section, guys, is the issue of bonus shares. Bonus shares in one single line can be said to be capitalization of reserves. Capitalization of reserves. That is the meaning of bonus shares. One share is already there. I am going to capitalize this. I have some, general reserve. I will capitalize the reserve and make it into bonus shares. I remember I told you when you issue the preference shares, you have to create something called CRR. This CRR can be used to pay bonus. Apart from that, what are the other uses where you can source the bonus is what this section talks about. Bonus share is a share allotment to the members by accumulated profits or distributable profits. Profits available, sources of bonus issue, very simple. Amount that can be used for bonus issue. How? By issue of freshly, fully paid up equity shares or free reserves or security premium account or already discussed CRR, capital redemption reserve account. First, partly paid up shares should be made fully paid and I can use the company's free reserves. But when I am touching what? The CRR. So no problem, I can do so because the only use of CRR is what? Capital redemption reserve account is to issue bonus shares. The member gets an advantage where the cost of acquisition is nil. Of the entire bonus shares, cost of acquisition is nil. That's why this fellow is telling here, yay is telling, see, yay. That's the thing. So if you see, even the infographics that we have created will help you understand the chart book in a different, better manner. So what is the reserve created by revaluation? Now, can I use the reserve created for revaluation for bonus issue? No. Revaluation reserve is a simple, entry in the accounts. That's it. It has got there is no real creation of value. It's just a book entry that cannot be used. That is the thing. So what is the rules of the bonus issue? It should be permitted under AOA. Means if AOA is silent, bonus cannot be issued. Then what? Recommendation. The board of directors should definitely recommend the bonus issue, after which the company in the general meeting should resolve to capitalize the reserve. There should be no default in deposit or debt. No default in employee statutory dues. Partly paid up shares should be converted to fully paid. And you cannot pay bonus shares in lieu of dividend. Means instead of dividend, I cannot pay bonus. Instead of dividend, cannot pay bonus. Cannot pay bonus. That is with respect to 63. Next, coming to 64. Notice to be given to the ROC for any alteration of share capital. So whenever I alter the share capital under section 61, I have to give a notice in form number SH7 within 30 days. SH7 within 30 days. If I don't do, all that fine etc. will be there. Very simple. Now 65. Reserve capital. Reserve capital is that portion of capital which is not called up, and it will be called up only to the event of and for the purpose of winding up. If the company is being wound up, only then it is called. Otherwise, reserve capital is not called later. So it is applicable only for unlimited company with share capital which seeks to convert into a limited company. At that point of time, I should have a reserve capital concept. That part of uncalled capital which will be called up only at the time of winding up. That is the scene. Then I told you guys, reduction of share capital, again important. 4 marks to 6 marks they can ask you. Here what is the procedure? An application for reduction in share capital is given in form number RAC1 with 5,000 rupees fees to be paid to the tribunal. Then tribunal will issue notice in 15 days. In RSC2 to the central government, in RSC2 to the SEBI, in RSC2 to ROC, in RSC3 to the individual creditors. Company should send notice to creditors within 7 days, that's what in RSC3, and also publish in the newspaper in RSC4. One English newspaper, one vernacular, and also display on the website. Company files the certified order within 30 days. Basically, I will have now, creditors will have 3 months to object. I will forward to everybody and they will have 3 months to object. Whatever objections etc. within 7 days, and whoever have to represent, within 7 days I have to represent to the tribunal. Basically, this is called principles of natural justice, opportunity of being heard. So I will have to file an objection within 3 months to the tribunal, who will immediately forward to the company within 7 days. And they will say, look boss, these are all the objections. Representation should be submitted to the tribunal. So whatever objections you have, I need to reply as a company. I will reply as a company and give it back to the National Company Law Tribunal. Now after everything, tribunal, if it is satisfied, whatever it is, company files a certified order copy. The tribunal will pass an order, and then the certified order copy will be then given to the ROC. ROC will confirm the same in RSC 7. This is the concept of internal reconstruction, reduction of share capital, where I want to reduce the shares. What shares? Issued shares, paid up shares, and all those things. That is with respect to section 66, reduction of share capital. One more very, very important provision that they keep asking in the examination would be buyback of shares under section 68. Buyback provisions under section 68. What do you mean by these buyback provisions? So basically, if the company wishes to feels that there are too many things happening in the company, there are excess funds in the company, and they wish to withdraw some funds, they will go through the option of buyback, section 68. What are the sources of buyback? One is, of course, you have the free reserves. Second, you have the securities premium account. Third one, proceeds of any fresh issue of shares, similar to the other part of redemption, and your security premium account can be used for this as well. Now, what are the conditions of buyback? It has to be authorized by AOA. If AOA is silent, buyback cannot happen. What should be the percentage of buyback of shares? Buyback, if it is less than 10% of the total paid share capital of free reserves, you can just pass a board resolution. But buyback is more than 10%, but up to the 25% of the total paid share capital and free reserves, then buyback can happen in every financial year. Maximum should not exceed 25% of the paid up share capital. What resolution is needed? Board resolution plus special resolution. Up to 10%, board resolution. Beyond 10%, board resolution plus special resolution is what is needed. Then the debt equity, this will come in law also, this will come in audit also. In law, they'll ask you what should the company check to understand whether buyback provisions are met or not. In audit, they will ask you what should the auditor do to ensure that his company, that buyback provisions are met or not met. That's the thing. So debt equity ratio is what has to be maintained as well. Debt equity ratio is debt divided by equity. So what is the total debt of the company? That is your secured loans, all unsecured loans, etc., and plus your capital and reserves, etc. So the debt equity ratio, debt by equity ratio should not be more than 2:1 after such buyback. Debt is to equity must be 2:1. all shares of the company must be fully paid up before buyback. Buyback must be completed within 12 months from the date of passing special resolution. The day you pass special resolution, buyback must be completed within 12 months. If shares are listed, then I have to follow SEBI guidelines as well without fail. SEBI guidelines have to be followed. I have to maintain a register of buyback as well. Apart from that, after making a buyback, can I issue shares? No. No further issue of shares within 6 months. Basically, if I buy back the shares, similar shares I cannot issue within 6 months, except if there is bonus issue, right issue. So I buy back shares today. In 2 months, can I issue bonus? Yes, that can be done. Between one buyback to the other buyback, maximum gap, right? The gap should be, minimum gap. Minimum gap should be 365 days. Between one buyback to the other buyback, minimum 1 year. 365 days around 1 year gap must be there. So the offer for buyback shall remain open for minimum 15 days, but maximum 30 days, after which you need to, do this entire procedure as such. And if you pass the special resolution today, everything should be completed as soon as possible within 12 months. And the gap between one buyback to the other buyback should be how many months? 365 days. 365 days. That is with respect to the issue of shares and all those things. Issue of shares. So this is my chapter number 3, which speaks about issue of shares. Then still coming to debentures, we have issue of debentures, section 71. Issue of debentures to be approved by passing a special resolution. If the company shall not issue any secured debentures, etc., unless it complies with the following condition, an issue of secured debentures will be made. Maximum redemption period will be 10 years. Beyond that, you cannot do. Of course, it should be secured on the assets of the company without fail. The company shall appoint a debenture trustee to look into all these debentures, etc. The debenture trust deed has to be framed within 60 days of the amount. The security for the entire debenture by way of charge shall be treated in favor of the debenture trustee itself. That is, it can either be a specific movable property or immovable property. Mind you, though the debenture holders are the beneficiaries of the particular debentures, it will be run by a debenture trustee and he will have a debenture trust deed. And the contract will be between the trustee and the company. Contract will be between the trustee and the company. That is what we need to understand. The contract will be between the trustee and the company. Any specific immovable property, it will be there. Now, if anything happens between the two, debenture holder, even though is a third party, he can sue. He can definitely sue on this without fail. That's the thing. Then I should create an account called as DRR account. Just like CRR, should also create an account called DRR, Debenture Redemption Reserve Account. This is as per section 71. Where debentures are issued by the company shall create a DRR account. Out of the profits available for payment of dividend, then the amount created is utilized only for the redemption of debentures without fail. That's what they say. Then DRR shall be created out of the profits of the company available for payment of dividend. So that's how it is. The DRR shall be created out of profits. The DRR should be created out of what? At least 25% of the amount. It should be raised how much? At least 25% of the amount should be raised through debenture issue. That's what it is. And ultimately, I should deposit with any scheduled bank, unencumbered securities I can invest in. The reserve can be used to invest in unencumbered securities, means risk-free securities of the government. Risk-free securities of the government. And the amount will be used only for redemption. DRR shall be used only for the redemption. Now you tell me, if I have shares, if I die, can I give the shares to somebody else? Yes. I need to nominate. The nomination power is given in section 72, power to nominate. Nomination is a process of assigning and identifying the best person to whom the securities will vest in the event of his death. So nomination will be in form SH13. Nominee is a person, any person including a minor can be a nominee, no problem. I have to follow SH13 and SH14. And then upon the death, after producing the valid evidence, then the nominee will be entitled to the rights. You can ask me a question, sir, in the nominee, my great grandfather has given in the nomination certificate, he has put my name. But in his will, in his own personal will, he has put my sister's name. Who will get the shares? The law is very clear. The nomination certificate will override the will. So nomination, whoever is there on the nomination certificate, that person will get the shares. So that is with respect to all these things, guys. Very, very simple. So buddies, with this we completed chapter number 4. So what we'll do is, if you see here in the material, we have completed chapter number 1 and 2 yesterday, 3 and 4 now. As far as the deposits and charges are concerned, this is very chilled out. So this will get over in less than half an hour, both deposits and charges, only 2 things to be maintained there. So what we are going to do tomorrow and day after tomorrow are very, 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 very important provisions, because tomorrow we will be doing chapter 5, 6 and 7. That is acceptance of deposits, registration of charges and management and administration. And the next day we will be doing 8, 9, 10. 8, 9, 10 is very important because it comes in law also and auditing also. Everything with respect to AGM, EGM, etc. will be doing tomorrow. So tomorrow we will be completing 5, 6, 7. And after tomorrow we will be completing 8, 9, 10. Right? So let's keep the class at 10:30. We'll keep it 10:30 to 1:30 instead of 10 to, or let's make it 10:15. Right? 10:15. Rather than 10, let's make it at 10:15. So the class will begin at 10:15. 10:15 to around 1:15, 1:30 maximum period. So the target is very simple now. Target tomorrow is 5, 6 and 7. As simple as that. Target the next day will be 8, 9 and 10. Got it? So we will see. So tomorrow we will finish off these chapters 5, 6, 7. In that, whatever is important we will do. Again, everything revising through the chart book. On that note, buddies, we shall now end the class today because we have finished our target. See you tomorrow at 10:15 where we will do chapter number 5, 6, 7. Alright. Thank you so much, guys, for your kind cooperation and for you to be here regularly without fail. Thank you so much.